Welcome back to The Deep Dive, the show that extracts core knowledge from the densest sources, giving you the shortcut to being truly well-informed. Today, we are taking a fascinating and maybe unexpected journey, a deep dive into legal history. It actually predates a lot of modern legal systems, but interestingly lays some groundwork for what we now understand as forensic investigation.
That's right. It's quite remarkable when you look back.
Our mission today is to explore a fundamental legal paradox, really. How do you deliver justice when the usual ways, the traditional avenues of proof, they just completely fail? We're diving into the early years of the Islamic State in Medina, focusing on a really critical criminal case where the law basically hit a wall because there were absolutely no eyewitnesses. None.
And our source material for this, drawing from some meticulous research compiled by figures like Mr. Zahir Ahmad Mir on the legal judgments of the Prophet Muhammad, peace be upon him, well, it provides a profound blueprint.
A blueprint? How so?
Because this isn't just some historical anecdote, you know. It's really the foundational document for the principle that judicial reason, careful thinking, must sometimes supersede just strict adherence to formalism, sticking to the rules no matter what.
Right. So we're looking at a specific case where the final verdict, the decisive one, it wasn't achieved through the traditional formal testimony that the new legal code might usually require.
Exactly. It came through something far more subtle and, I'd argue, more intellectually demanding.
Which would?
Careful reasoning applied to physical evidence. That act of deduction, of using inference to bridge the gap between the crime itself and the hidden truth. That's the essence of forensic thinking. And here it is being practiced almost 14 centuries ago.
Wow, okay.
And what's truly important for you, the learner, to grasp is the principle this case established. It really solidified the validity of what became known in Islamic law as qarīnah.
Qarīnah.
Yeah.
That's circumstantial evidence.
Precisely. Circumstantial evidence. And this case defined the jurisprudence of judicial decision-making, something called Fiqh al-Qada, as a system that actively valued rigorous investigation and applied reason, or equal, as it's known.
Okay, equal reason.
Yes. And crucially, it signaled that this legal framework was never meant to be one of just sort of blind formalism. It wasn't about ticking boxes if it meant ignoring the obvious truth.
And to really understand the immediate high-stakes importance of this judgment, we have to note the initial context, right? This wasn't just any case.
No, definitely not. The case involved the murder of a woman from the Ansar. These were the core Muslim residents of Medina, the hosts, essentially.
Okay.
But the investigation, it quickly pointed toward a man from a neighboring Jewish tribe.
Ah, okay. That adds a whole layer of complexity.
It absolutely does.
Yeah.
That specific socio-political dynamic immediately forces the investigation to be, it had to be entirely impartial and demonstrably rigorous. There was no room for error or perceived bias.
Because the Prophet, peace be upon him, he had to prove that his system of justice was universal, fair to everyone.
Exactly. Regardless of tribal affiliation, religious background, political ties, none of that could matter. The stability of the entire, nascent state really hinged on a just resolution here.
Okay, let's unpack the scene then. This sounds critical.
Right. So, to really appreciate the legal gravity and, frankly, the political pressure surrounding this specific case, we have to try and immerse ourselves in 7th century Medina.
Which wasn't exactly a stable, established empire yet.
Not at all. It was a young, often fragile commonwealth. It was attempting to integrate quite diverse groups. You had the Muslim immigrants from Makkah, the Muhajirun,
Right.
the local Muslim residents, the Ansar, who we just mentioned, and also several large Jewish tribes, all living together under a single new constitution, the Charter of Medina.
So any act of violence, especially something like murder, it wasn't just a crime against an individual?
No, it was much more. It was a systemic threat. It genuinely risked unraveling that fragile social contract they were building.
How so?
It could easily send the community spiraling back into the destructive cycle of tribal vendettas, that old tribal loyalty known as asabiyya. You defend your own, right or wrong.
Ah, okay. So the state, the new Islamic State, needed to show its authority, that it could deliver justice more reliably than the old ways.
Precisely. It had to prove that its justice was stronger and more reliable than the ancient tradition of blood feuds and tit-for-tat tribal conflicts.
So what was the specific tragedy that set this crucial precedent?
Well, the sources tell us it was the finding of a woman from that Ansar community. She was discovered murdered somewhere near the city's outskirts.
Okay, just found there.
Yes. And you can imagine the immediate sense of violation, the fear, and also the intense communal pressure that must have surged through the Ansar community. They needed answers.
Yeah.
And they needed justice from their new judicial authority, from the Prophet himself. Hashtag 1.1, the incident and the community shock.
Okay, so the body is found, the community is in shock, but the narrative emphasizes this immediate legal hurdle that popped up straight away, this void of proof.
Yes, that's the crux of it initially. You see, traditional legal frameworks, not just but across many early societies, placed an incredibly high burden of proof on the accuser.
Right, you couldn't just accuse someone lightly.
Especially not for serious crimes. Often these systems required explicit, direct testimony to establish the facts beyond, well, any doubt. Certainty was key.
And for capital crimes, like murder, that standard must have been even higher.
Oh, absolutely. Particularly stringent. Justice, in those cases, typically required one of two things. Either a full, freely given confession from the accused,
Okay.
or the direct testimony of two credible male witnesses who actually saw the crime unfolding. They had to have witnessed the act itself.
Wow. 2 eyewitnesses to the very act. That's difficult to get.
It is. And this standard, it was designed for a good reason. To protect individuals from wrongful conviction. To make sure the state only intervened based on absolute certainty.
But the problem here, when this woman's body was discovered, was that the community realized pretty quickly they had nothing. No immediate path forward under that strict rule.
Exactly. There were absolutely no direct witnesses. Zero. No one stepped forward saying they saw it. No one reported hearing a struggle. And the primary suspect, at least initially, offered a staunch denial. Flat out said it wasn't him.
So if the whole judicial process relied only on finding those 2 eyewitnesses?
The case would have stalled.
Ew.
Immediately. It would have gone cold right there.
And the sources highlight this difficulty, right? Because failure here wasn't just a legal problem.
Oh, no. Failure to achieve justice in such a public and tragic case, especially one involving different community groups, it would have been devastating. Politically, socially.
It would suggest the legal system cared more about procedure than truth.
Precisely. It would have meant that a legal system prioritizing formal procedure, even over fundamental truth, had failed to protect its people. And that risks social destabilization, a return to those old tribal ways.
Yeah, you can really feel the pressure building, an unsolved murder, especially with potential intercommunal tension. It's a powder keg.
Absolutely.
Yeah.
If the state couldn't deliver definitive justice based on truth, even when that truth was hidden, not immediately obvious, the pressure on the prophet, peace be upon him, to intervene personally and find a solution must have been immense. Hashtag 1.2, the personal involvement of the prophet.
Which is exactly what happened, right? He didn't just hand it off.
Correct. This is precisely why his personal involvement was so crucial. He didn't simply delegate the matter to a judge or a representative. The sources are clear. He personally led the inquiry.
And what did that signal to everyone?
Well, it immediately signaled the gravity of the case. It showed the commitment of the highest authority to finding the truth, and crucially to impartiality, especially given those intercommunity dynamics we mentioned.
Right, the Ansar and the Jewish tribe.
Yes, it moved the investigation from just being, a local police matter into a critical test of the state's entire judicial capacity, its fairness, its effectiveness.
So his personal involvement basically established a standard that a judge, maybe especially in complex cases, isn't just supposed to sit back and wait for evidence.
Exactly. It set the precedent that the judge isn't a passive recipient of whatever evidence happens to wander into the courtroom. The judge has an active, almost a moral duty to seek out the truth, to scrutinize it, even if that requires stepping outside the usual bounds of just receiving formal testimony.
Okay, so he takes charge. What did he actually do? How did the investigation proceed? Can we deduce the steps from the legal sources?
We can. The sources suggest a methodical approach. The very first step seems to have been a meticulous examination of the circumstances.
What does that mean practically?
Well, it suggests a careful physical review of the crime scene itself and the immediate environment around where the victim was found. Think of it as the earliest form of forensic reconnaissance.
So not just looking at the body, but the surroundings.
Definitely. Examining the ground, the foliage, noting the proximity to various homes or pathways, basically gathering all the physical context.
Okay, step 1. Examine the scene. What next?
Secondly, the prophet, peace be upon him, employed a broader community-based questioning process. He questioned neighbors.
But not necessarily looking for that formal eyewitness who saw the murder itself?
Not exclusively, no. It seems he was gathering more subtle context, looking for anomalies, maybe nonverbal indicators. Who left their home early that day, who returned late. Did anyone see an individual acting suspiciously nearby, even if they didn't witness the actual homicide?
So, collecting behavioral data, environmental data points
In a
almost.
sense, yes. Building a picture of the relevant time frame and location.
And the third step, you mentioned subtle clues earlier.
Yes, and this is really the heart of the investigative mandate that emerged here. He actively followed subtle clues. This is the recognition that the environment itself, the physical reality of the crime scene, it can act as a silent witness.
The traces you mentioned.
Exactly, the traces. The physical evidence provides information that speaks even when human witnesses are silent or completely absent. And this detailed, hands-on methodology scene examination, broad questioning following physical clues, this became the template for future jurists. It established that active investigation is a core part of the judicial function, not separate from it.
Okay, so the standard procedure relying on witnesses failed. But the need for justice obviously remained. So the Prophet actively shifted the focus from just waiting for witnesses to actively seeking out physical evidence and using logical inference.
That's the key shift.
The big question then becomes, what exactly did he find? What were these traces that broke the case open? All right, so the investigation starts in silence, legally speaking, no witnesses. But this intense, methodical scrutiny you described, led by the Prophet himself, finally yields the clue they need.
Yes. And this is where that concept of qarīnah, circumstantial evidence, moves from being just an abstract idea to something very practical, very real. Because the key to solving this murder turned out to be purely physical.
Not words, but things.
Exactly.
Yeah.
The source material focuses really intensely on this one piece of evidence that stood out. And it specifies, these were traces found near the crime site.
We need to unpack that. Traces in 7th century Medina. What does that likely mean? We're talking pre-CSI here.
Right. We have to think contextually. These traces, these physical indicators or disturbances left behind, they provided the critical inference. They were the puzzle piece.
So could they have been footprints? Maybe distinctive ones in the sand or earth?
That's a strong possibility. Given the likely terrain around Medina Sandy, earthy footprints are very plausible, perhaps indicating a specific type of sandal or even a particular gait, something unique to a person or maybe a group.
Or maybe something else. Scuff marks, broken twigs.
Could be. Signs of a hasty withdrawal, unusual scuff marks, maybe the presence of specific materials not commonly found right in that area, a dropped piece of cloth, a tool fragment.
Okay. But the power of these traces wasn't just that they existed, right? It was the precision of the inference they allowed.
That's the critical point. For this evidence to be definitive enough to act upon, it couldn't just be, say, a generic footprint that half the town might leave. It must have suggested a highly distinctive set of physical circumstances.
Like
A very specific path taken away from the scene, a unique direction of travel, perhaps only consistent with heading towards one particular area. Or, most critically, maybe implements or items were left behind or impressions made that were culturally distinct, associated with one group more than others. Hashtag 2.1, the specific clues discovered.
And here's where it gets really specific and frankly stunning for that era. The source tells us these traces indicated quite directly that the crime was committed by a man from a nearby Jewish tribe.
Yes, that level of specificity, derived solely from physical evidence, is phenomenal. It really demonstrates the strength of the deduction that was made.
Let's think about the implications of that for a second. To narrow down the pool of suspects from the entire diverse population of Medina Muhajirun, Ansar, various Jewish tribes, down to one specific communal group, based only on physical traces.
It means the evidence had to be overwhelmingly strong, compelling.
So maybe the tracks led directly and only towards the area where that tribe lived, without deviation.
That's one possibility. Or perhaps there was some material residue left behind, like a specific type of cloth fiber known to be used by them, or a fragment of a tool particular to their craft, or even, as you suggested, distinctive soil or material tracked from that tribe's specific residential or farming land, something that allowed for a direct, logical correlation.
This step seems crucial because it shows the evidence, the qarīnah, wasn't just used later to confirm a suspicion they already had.
Exactly. It seems it was the driving force for discovery. It was what narrowed the entire investigation down from potentially hundreds of people to a much smaller, defined group.
And that's important legally, right? It prevents the inquiry from just falling into generalized suspicion or, worse, relying on existing prejudices between groups.
Absolutely. It grounds the investigation in objective, physical indicators rather than subjective biases.
And this moment is critical legally. It demonstrates that the strength of the inference, the conclusion drawn from the physical facts, was deemed legally sufficient to actually target an individual, or at least a specific group, for further investigation.
Yes, and importantly, even when the potential suspect belonged to a non-Muslim community, this demanded absolute impartiality in how the investigation proceeded based on that evidence. Hashtag 2.2, establishing motive and confrontation.
Okay, so the physical evidence points strongly towards someone from this particular tribe. What happens next? You can't convict on just traces alone, surely.
No, and this is where the investigations shift to connect that physical presence to a rational cause. This is where human motivation enters the equation. The physical evidence needs a logical partner.
Finding a why.
Exactly. The investigation quickly moved to find that rational link, and this establishes a key principle. Physical evidence is always strongest when it's supported by a plausible motive.
So did they find one?
They did. The inquiry revealed that the specific Jewish man, who was presumably identified more closely once the focus narrowed to the tribe and perhaps based on the specifics of the traces, had an unresolved dispute with the murdered woman.
Ah, there it is, the connection.
Yes, this is the essential link that transforms the case from just being, circumstantial suspicion, someone from that area was there, into something approaching logical certainty.
Because the physical traces established the means and opportunity, the perpetrator was physically present at the scene and then fled.
Right.
And the unresolved dispute establishes the motive, the potential reason for the act itself.
Precisely. When you combine those two elements, the distinct physical evidence pointing towards this man or his group, plus a clear pre-existing motive, you generate what the legal system would consider overwhelming rational proof.
It stops being just a collection of random facts.
Exactly. It coalesces into an undeniable narrative of guilt. And this is the moment when the circumstantial case, built on traces and motive, arguably became stronger, more compelling than any potential conflicting testimony or denial could be.
So, with this circumstantial case now logically watertight, what was the next step? Confrontation.
Yes. The source material describes the man being brought before the prophet, peace be upon him, and it says he was subjected to confrontation and careful questioning.
What does confrontation imply here? Just asking him questions.
It likely implies more than a basic interrogation. It suggests that the judge, the prophet himself, laid out the evidence systematically before the suspect, presented the facts.
Like, here are the traces leading from the scene towards your area. Here is the evidence of the dispute you had with this woman. Explain this.
Something like that, yes. The strength of this logical deduction, based on the combined physical evidence and the motive, was apparently so compelling, so rationally irrefutable, that his initial denial just couldn't hold up against the weight of the facts presented to him.
So it was the physical evidence, the qarīnah, that really acted as the key lever here. It dismantled his defense.
It seems so. It led ultimately to securing the necessary confession. And in the hierarchy of proof within Islamic law, as in many systems, a free and clear confession is considered the ultimate establishment of certainty, the gold standard.
So the circumstantial evidence wasn't just about convicting him directly.
No, its primary role here was to guide the inquiry effectively, to break through the silence and the denial, and uncover the ultimate truth, the confession. It upheld justice precisely when the traditional method, eyewitness testimony, was completely non-existent.
That sequence is really vital, isn't it? It shows qarīnah isn't intended as a replacement for truth, but as a tool to uncover truth.
Perfectly put. If the truth is hidden, the principle established here is that the judge must employ reason and evidence proactively to bring it forward. The legal process shouldn't just end in failure because of procedural silence or a lack of cooperative witnesses. Hashtag 2.3, the judgment and restoration of justice.
Okay, so the confrontation, based on the strength of the circumstantial evidence, leads to a confession. What happened then?
Following that confession, the judgment was swift and definitive. The prophet, peace be upon him, ordered the prescribed punishment.
Which for murder in Islamic law is retaliation, right? Qisas.
Yes, qisas, which typically means like for like, although options for forgiveness or blood money, daya, also exist depending on the victim's family's wishes. But the key point is, the legal sentence for murder was pronounced.
And for the victim's family, the Ansar community, and maybe the wider community that was watching this unfold.
This represented the full restoration of justice. An answer had been found, the truth uncovered, and the law applied fairly.
So the crucial takeaway here isn't just the verdict itself, but the path taken to get there.
Absolutely. Justice was achieved, but not through the expected formal route of explicit, direct eyewitness testimony. It came through an innovative, certainly for its time, and careful application of rational reasoning to meticulously gathered physical evidence from the scene.
It established that certainty, legal certainty, could be achieved through rigorous deduction.
Yes, and that's why this narrative serves as such an ancient yet foundational case study. It proved the vital necessity of proactive, intelligent investigation as an essential prerequisite for administering justice, especially in complex criminal matters where the truth isn't immediately obvious.
It really is like the original CSI ruling, in a sense, using the scene to solve the crime.
In a very fundamental way, yes.
Yeah.
Okay, so having navigated the narrative of the case itself, the crime, the investigation, the resolution, we really need to transition now to the legal philosophy, the principle that cemented this incident into the very structure of Islamic law.
Right, because the enduring legacy wasn't just solving one murder.
No, far from it. The primary lasting legacy of this judgment is the definitive establishment and, crucially, the definition of qarīnah.
And this is the absolute core concept for you, the learner, listening today. We need to be crystal clear on what qarīnah means.
Let's define it again. Qarīnah is circumstantial evidence. It's proof that's derived not from direct observation of the main fact in question, in this case, the act of murder itself,
Okay.
but rather from secondary facts. Things like the traces found, the established motive, the location, the timing. Facts that, when put together, logically necessarily lead to a rational inference about that primary fact, namely guilt.
So it's connecting the dots, essentially.
It is, but in a very rigorous way. And crucially, the Prophet, peace be upon him, established the legal admissibility of qarīnah specifically in the absence of direct witnesses. He sanctioned its use.
But surely there were limits. It couldn't just be any circumstantial clue, right?
Absolutely not. This permission was highly constrained. The principle established was that qarīnah can be relied upon only if it leads to a strong and rational inference of guilt. That phrase is the key.
Okay, strong and rational inference. Let's spend some time on that. What separates that from just suspicion or a hunch?
That's a vital distinction. Islamic law clearly differentiates strong inference from mere suspicion, which is called zan.
Zan.
Zan suggests just a possibility, maybe a conjecture, a gut feeling perhaps. And zan is never considered sufficient grounds for conviction in Islamic law, especially not in serious criminal cases, particularly capital cases. It's explicitly warned against in the Quran.
So strong and rational inference means something much more solid.
Much more. The standard requires that the circumstantial facts, when put together, must point to the conclusion of guilt so overwhelmingly, so powerfully, that any other explanation becomes rationally improbable, or even logically impossible.
So it's about logical necessity. The conclusion has to follow from the facts.
Yes, that's a good way to put it. Logical necessity. In the murder case we've been discussing, the combined evidence, those specific traces pointing to the tribe or individual, the proximity of the suspect, the clear unresolved dispute, all these pieces together created a tapestry of certainty that left virtually no room for reasonable doubt. Any alternative explanation just wouldn't fit the known facts.
Okay, that makes sense. But I have to ask, even with that high standard, doesn't relying on inference, on deduction by a judge, risk, well, judicial overreach, or just human error? How did the early jurists make sure that strong and rational didn't just become a subjective feeling in the judge's mind?
That is the pivotal question, isn't it? And it's precisely why this principle, while accepted, was also highly scrutinized and carefully limited by later jurists. They were very aware of human fallibility.
So how did they maintain the rigor? What were the safeguards?
There were generally two key methods discussed. First, the evidence. The different pieces of qarīnah ideally had to be mutaratif, meaning corroborating, mutually reinforcing. Multiple independent pieces of circumstantial evidence all had to align perfectly, pointing in the same direction. If the physical traces suggested one thing, but the motive evidence pointed somewhere else entirely, the inference would fail. The pieces had to fit together seamlessly.
Okay, so consistency across different types of circumstantial evidence. What was the second safeguard?
The second, and perhaps more fundamental, was the requirement for the judge to articulate the rational chain of logic publicly. The reasoning couldn't just be internal.
Ah, they had to show their work.
Exactly. The standard wasn't just something felt by the judge, it had to be proven through articulated reason. The judgment had to explain how the circumstantial evidence led necessarily to the conclusion of guilt. This made the reasoning transparent and, importantly, reviewable by others. It guarded against purely subjective decision-making, #tag 3.2, the Hadith reference, and ratio decidendi.
Okay, so the principle is established, defined, and safeguarded. To really solidify the legal position of qarīnah for later generations, jurists would need a direct source, right? Something textual to point to.
Yes, absolutely. Legal precedent in Islam relies heavily on foundational texts, and later jurists did rely on the direct source that codified this specific ruling by the Prophet, peace be upon him.
So we need to cite that specific reference, the textual proof for using this methodology.
Right. The specific ruling, the incident we've discussed, is narrated by Ibn Abbas, a respected companion of the Prophet, and it's found in authoritative collections of hadith, like Sunan Abu Dawud. The reference often cited is hadith number 4529 in that collection.
And what does that hadith confirm?
It confirms the core facts that the Prophet Muhammad, peace be upon him, judged on the basis of circumstantial evidence, qanun, in the case of the murdered woman, specifically in the absence of the standard requirement of witnesses or a confession initially, and consequently ordered the prescribed punishment, qisas, against the accused after the evidence led to the confession.
So that concise legal statement recorded in a major hadith collection becomes the bedrock.
It is. It confirms that this method isn't some weird exception or later invention. It's a divinely sanctioned path to justice, approved and used by the Prophet himself, specifically for situations where the traditional methods fail to reveal the truth.
But beyond just the ruling itself, there's the why, isn't there? The true intellectual weight often rests in the philosophical rationale behind a ruling, what lawyers might call the ratio decidendi.
Precisely. And the legal sources, the commentaries on this hadith and related principles, they articulate the profound reasoning behind this judgment. It's often summarized by highlighting the moral and intellectual obligation placed upon the judge.
Which is?
It's often encapsulated in sayings derived from the principles of justice in the Quran and Sunnah, emphasizing something like this. Where truth cannot be seen by physical eyes, it must be sought through reason, for Allah loves those who judge with fairness.
Wow, okay, that's powerful. Where truth cannot be seen by eyes, it must be sought through reason.
It fundamentally redefines the scope of judicial duty, doesn't it? It elevates the pursuit of justice beyond just, ticking procedural boxes or following a checklist.
It's an explicit mandate that the intellect aql, as you said, must be fully engaged.
Yes. Engaged to connect the visible facts, the traces, the circumstances, to the hidden reality of the crime. To uncover what truly happened.
Think about the implication for the judge's conscience, then.
Exactly. If a judge, through meticulous investigation and applying strong logical inference, becomes certain or achieves that high degree of certainty required about who the perpetrator is, but then refuses to act simply because the formal witnesses required by a different type of proof aren't present.
Then that judge has failed.
According to this principle, yes. That judge has failed the intellectual and moral mandate of fairness, of seeking truth. So, relying on proper investigation and sound reason, when done correctly, becomes almost an act of piety, an act of fulfilling the trust of judgment, not just a matter of legal practicality. Hashtag tag 3.3 Justice and Rationality.
This philosophical grounding, this emphasis on reason seeking truth, it feels like a direct and powerful challenge to any temptation towards absolute formalism, right? That idea of blind formalism you mentioned earlier.
It is a very direct challenge. It confirms that Islamic justice, at its core, is not intended to be a rigid, inflexible box. It's meant to be a dynamic system that deeply values reason, probability when it reaches the level of near certainty, and rigorous investigation, placing these above the mere mechanical ticking of procedural boxes when those boxes obstruct the path to truth.
Because formalism in this specific case would have meant what?
It would have meant the case stalled indefinitely. The crime goes unsolved, the murderer goes free, the victim's family gets no closure, and the community sees the legal system as ineffective. That's injustice.
So this ruling essentially confirms the priority of substantive justice over strict procedure if that procedure is blocking the discovery of truth.
When the procedure designed to ensure certainty actually prevents certainty from being reached through other valid means, yes. It's a declaration that the evidence provided by the physical world, by reality itself, when interpreted logically and rigorously, carries immense legal weight. It cannot simply be ignored.
And this brings in that vital legal concept you mentioned, the interplay between aql, intellect or reason, and naq, transmitted revelation or tradition, like the Quran and Hadith.
Exactly. The judge must use their God-given reason, their aql, to interpret the reality presented by the physical evidence, guided by the principles found in the naq. It grounds the legal system firmly in both revelation and practical intellectual honesty. It connects faith and reason in the pursuit of justice.
And there's also that moral imperative, especially given the context of this case.
Yes, let's not forget that. In an environment where the accused was from a non-Muslim tribe, the impartiality of the state, led by the Prophet, had to be absolutely unquestionable.
So basing the verdict ultimately on overwhelming objective physical evidence and reason, rather than potentially relying on the testimony of community members who might have biases.
That was arguably the only path to demonstrate universal fairness in that specific delicate situation. It showed the ruling was based on facts, not on affiliation.
So, qarīnah, circumstantial evidence, properly applied, became this essential tool. It ensured the law remained relevant to human reality, to how crimes actually happen and how they can be solved.
It enabled judges to actively pursue and establish truth, confirming that the legal system wouldn't just sit back and wait for miracles or perfect witnesses. It mandated the active use of the intellect and the available evidence to achieve justice.
Okay, it's genuinely staggering to think about this. One complex murder case back in 7th century Medina with no witnesses. It didn't just provide a solution for that specific time and place.
No, it became much more. It effectively became the definitive legal precedent that shaped evidence law for the entire Islamic legal tradition, right across the following 14 centuries. Its ripples are incredibly wide.
The significance then really can't be overstated.
I don't think so. This ruling immediately became the foundational precedent for what we can broadly call forensic inference and circumstantial proof within the vast body of Islamic jurisprudence dealing with judiciary matters, Fiqh al-Qada.
So it gave later jurists the necessary legal authority, rooted in the Prophet's own practice, to actually admit and utilize things like physical traces, medical facts, logical deductions in criminal cases.
Yes, precisely. Once that standard of strong and rational inference was set by the Prophet himself, the door was opened, cautiously but definitively, for the inclusion of all sorts of objective physical evidence that could meet that high bar.
So this one precedent effectively paved the way for accepting things like medical reports later on, or analyzing bodily evidence, or using expert forensic opinions as societies developed.
Absolutely. All of that logically flows from the initial ruling on those crucial traces near the crime scene. It established the principle that physical reality, when rigorously analyzed, speaks truth in a court of law.
It really speaks to the pragmatism, doesn't it, and the intellectual resilience of that early legal system.
It does. It feels like they anticipated, perhaps, that as societies become more complex, criminals would inevitably try to conceal their actions more effectively. Witnesses might be intimidated or simply not present.
And a system relying solely on direct eyewitness testimony would quickly become outdated, maybe even ineffective in many situations.
Exactly. It would severely hamstring the judiciary's ability to uncover the truth and protect the populace from hidden crimes. This ruling ensured the system had another tool, a powerful one based on reason. Hashtag 4.1 Foundation for Forensic Inference.
So this specific case allowed the juristic foundation for evidence to be built on, well, on reality, on verifiable facts, not just on the possibility of someone seeing something.
Well put. It ensured that forensic investigation, in its broadest sense examining the facts of the scene and the context, became intrinsically linked to the very concept of judicial fairness in Islam.
Because otherwise, justice might depend purely on luck, the luck of having a witness.
Indeed. The jurists who followed acknowledged that crimes, especially serious ones, often occur in private, obscured circumstances. If the physical facts practically scream the truth, but the legal system has to ignore that scream because of a formal requirement for a type of witness who just wasn't there, well, the result's injustice.
So this ruling ensured that physical evidence, when it's scientifically sound by the standards of the time or ours, and logically verified to meet that high inference standard, holds legitimate legal authority. It has weight.
Yes, and we should remember this precedent was particularly vital not just for capital crimes like qisas, but also potentially for crimes related to property or accusations of adultery, where the traditional direct witness requirements were often extremely difficult, if not impossible, to meet.
So qarīnah provided the necessary framework to deliver justice in those really challenging scenarios, without just arbitrarily lowering the traditional standard of certainty required for conviction. It offered an alternative path to the same high level of certainty.
That's the key. It wasn't about making convictions easier. It was about allowing certainty to be established through rigorous reason and evidence when testimony wasn't available. Hashtag 4.2 Influence on major jurists.
Okay, so the principle is established by the Prophet. How did it get cemented and carried forward? Its acceptance and codification by later major jurists must have been crucial for its longevity.
Absolutely crucial. If the major schools of thought hadn't adopted it, it might have remained a historical footnote. But this ruling fundamentally influenced the structure of evidence law within all the major Sunni schools of thought, ensuring its validity and breadth across the entire Muslim world.
So we see its clear, direct influence on some monumental figures in legal scholarship.
Yes, definitely.
Yeah.
Figures like Imam Malik, the founder of the Maliki school, Imam Shafi'i, founder of the Shafi'i school, and perhaps particularly emphasized by the later Hanbali scholar Ibn al-Qayyim.
The fact that these foundational figures, representing different methodological approaches sometimes, all incorporated qarīnah, that really proves its undisputed status as a valid legal methodology, doesn't it?
It really does. Let's consider Imam Malik for a moment. His Maliki school, which originated in Medina itself, placed significant emphasis on the value of local customs and, importantly, the established judicial practice amal of the people of Medina.
And this case was a direct judicial practice of the Prophet right there in Medina.
Exactly. So for Malik, its incorporation into Maliki jurisprudence was almost inevitable and certainly foundational. Maliki jurists subsequently explored the nuances and limits of circumstantial evidence quite extensively, particularly in cases where suspicion was very high, but witnesses were absent.
Okay, that makes sense for Malik. What about Imam Shafi'i? He's often seen as prioritizing strict textual adherence, the explicit words of the Quran and Hadith, sometimes over local practice or broad reasoning. How did he integrate this concept?
That's a good point. Shafi'i was indeed often more cautious regarding the expansive use of analogy, qiyas, or reliance on local custom, compared to, say, Malik or Abu Hanifa. However, he still accepted the validity of qarīnah in principle, because it wasn't just based on general reason, it was based on a direct judgment by the Prophet himself, confirmed by specific hadith, like the one in Sunan Abu Dawud we mentioned. For Shafi'i, that textual proof from the Sunnah was key.
So he accepted its admissibility.
Yes, the admissibility of qarīnah was maintained in the Shafi'i school, but perhaps with an even greater emphasis on ensuring the strength of the inference was extremely high. Often, Shafi'i jurisprudence would require that the circumstances leave absolutely no possible alternative explanation that could reasonably lead to innocence. The certainty had to be almost absolute.
So accepted, but maybe with a slightly higher bar for the inference itself.
Arguably, yes, reflecting his general caution with non-textual proofs.
And then later you mentioned Ibn al-Qayyim. He's often cited in discussions of Islamic evidence law and seems quite relevant to our sources. He was known for his comprehensive treatment of evidence, wasn't he?
Very much so. Ibn al-Qayyim, writing centuries later but drawing on all the earlier discussions, seems to have been perhaps the most enthusiastic and systematic proponent of deductive reasoning and qarīnah among the major scholars.
How so?
He heavily leaned on reason and logic, al-Qul, arguing forcefully in his works, like al-Turuq al-Hukmiyah, the Paths of Judgment, that certainty derived from overwhelming physical indicators and logical connections is legally equivalent, and sometimes even superior, to certainty derived from potentially flawed or mistaken human testimony.
Superior? That's a strong claim.
It is, but he argued that physical facts don't lie or forget, whereas human witnesses can. He used this principle to argue strongly for the inclusion of technical evidence, expert opinions, and forensic observations available in his time, solidifying the notion that logical inference is a fully valid, indispensable source of judicial truth across the board, civil, criminal, family law.
So the scholarly consensus across these major schools, maybe with slightly different emphasis, essentially confirmed that the principle of qarīnah wasn't some fringe idea or a loophole. It was a vital, necessary element of a just and functional legal system.
Absolutely. It ensured that Islamic justice remained pragmatic, intellectually sound, and capable of addressing the complexities of real-world crime. Hashtag 4.3 modern legal survival.
Which brings us, remarkably, right up to the present day. It is truly remarkable that a legal concept established under these very specific 7th century conditions in Medina remained actively enforced and codified in contemporary legal systems.
It is quite amazing, isn't it? This continuity really speaks volumes about the original ruling's practical depth and enduring relevance. It wasn't just tied to its immediate context.
So let's discuss that contemporary relevance. You mentioned earlier that this ancient ruling isn't just history. The principle survives today in modern Muslim jurisdictions. The source specifically cited Pakistan.
Yes, the source material highlights this direct lineage. This ancient precedent isn't relegated to dusty history books. It forms a cornerstone of current legal practice in many places. A key example given is its codification in Article 135 of the Qanun-e-Shahadat Order of 1984 in Pakistan.
Okay, the Qanun-e-Shahadat Order, 1984. That's Pakistan's main law of evidence, replacing the old Evidence Act inherited from British India.
Correct. It's a comprehensive law designed to align the rules of evidence more closely with Islamic principles. And Article 135 deals specifically with the relevance and proof of facts, allowing for inferences.
That's genuinely a 1,400-year chain of legal continuity we're tracing here. From a murder investigation in Medina to a specific article in Pakistan's modern evidence law. What does Article 135, or the principle it embodies, specifically mandate regarding circumstantial evidence today?
Well, the modern application, as reflected in laws like Pakistan's and the jurisprudence surrounding them, faithfully mirrors the original standard established by the Prophet, peace be upon him. Circumstantial evidence, qarīnah, is admissible in both civil and criminal trials.
But
There's always a but. There's the crucial condition. It is admissible when it's corroborated by reasoning. That link back to reason, is essential. The evidence can't just be vaguely suggestive on its own.
so the judge or the jury, they still have to perform that same intellectual duty we discussed earlier. They have to connect the dots.
Precisely. They must connect the traces, whatever form they take today, to the conclusion of guilt through that strong, inescapable, logical necessity. The inference must be rational and compelling.
So it doesn't matter whether the evidence is 7th century footprints in the sand near Medina, or 21st century DNA analysis from a lab, or complex financial data trails from a computer. The fundamental legal standard remains the same. Does this piece of evidence, when combined with other facts and analyzed through pure, rigorous reason, lead to a strong and rational inference of guilt that excludes other reasonable possibilities?
That is precisely the enduring principle. The concept of qarīnah ensures that the legal system remains flexible enough and capable enough to address crime using whatever objective evidence the natural world or modern technological advancements provide.
But it always mandates that intellectual rigor, that adaptability.
Yes, cementing its role as a true cornerstone, not just of Islamic evidence law, but arguably contributing to the broader global understanding of the power and place of circumstantial evidence. It highlights the profound practicality embedded in these early judicial judgments. #tag outro.
Wow, okay. We began this deep dive with just a single, albeit complex, murder case. A case lacking witnesses, occurring in a fragile early state. And we've traced its legacy all the way to the foundation for modern forensic inference and evidence law, still active today.
It's quite a journey. We've thoroughly explored the power of qarīnah, that concept of circumstantial evidence, and really established how the Prophet Muhammad, peace be upon him, personally ensured that justice was served through meticulous, proactive investigation and, crucially, rigorous reason.
And that demonstrated, didn't it, that the pursuit of truth requires real intellectual effort. Analytical engagement. It's not just about procedural formality.
Absolutely. The central finding, I think, that resonates through the centuries is that the judge holds this active mandate, a mandate to use reason, to use intellect, aql, to bridge that often difficult gap between the visible, physical facts we can find and the hidden, singular truth of what actually occurred in a crime.
It's really an instruction for the judiciary, for anyone involved in justice, to be smart, to be critical, and to be relentlessly analytical in pursuit of that truth.
Which brings us then to our final provocative thought for you, our listener, to perhaps chew on.
Okay, let's hear it.
If the enduring legal mandate established way back in this foundational case requires judges and investigators to actively engage their analytical skills, their equal, to bridge that gap between visible facts and hidden truth, how does this profound responsibility translate to our modern world? Specifically to the often overwhelming volume of digital qarīnah we face today.
Digital circumstantial evidence.
Yes. Are our current legal systems, sometimes burdened by the sheer complexity and volume of data trails, geolocation logs, complex technological footprints, are we applying the same intense level of logical rigor, the same demand for inescapable rational necessity to digital evidence that was applied to those few but definitive physical traces found near Medina 14 centuries ago?
That's a challenging question. Is the standard of strong and rational inference being maintained with the same rigor in the digital age?
It's something to consider, because that fundamental search for certainty, achieved through rigorous rational inference from the available evidence, remains the bedrock of justice, regardless of the era, regardless of the technology. The principle endures. The challenge is always in its faithful application.